Salutations, respected viewers. This is George from Ireland, continuing my series on an introduction to English law and looking more at the nuts and bolts of law, particularly out-of-court settlements. There is so much focus on courts and courtroom battles that people often overlook the fact that most legal work happens outside of court. Barristers are preparing their briefs. They receive all these documents from a solicitor who's briefing them, and they're going to need to master the documents, marshal the facts, then go into court. They're meeting their clients. Even if it's just one barrister, one client, it's called a conference, which could be misleading. Solicitors are meeting clients, they're preparing documents, they're looking things up on LexisNexis and so on. They're writing official letters, they're drawing up contracts, and they're replying to other people's letters. So law firms advise their clients. They make out-of-court settlements. Solicitors are handling property transactions, divorces, wills, prenuptial agreements, and on and on. So none of that involves a day in court in most cases. So people litigate against each other, as it means they try to sue each other. And it's said that we're becoming more litigious, as in more inclined to sue people. And it's reached epidemic levels in the United States. As one judge said, obviously we want people to have remedies if they're wronged, but do we really want it to reach the state where it's like the national hobby? People usually make an agreement, and they often don't go to court. This reduces the risks for both sides. It also reduces the potential gain if you're the winner. The side that pays out will have to pay out less than if he lost in court through this out-of-court settlement. The side that receives money often receives less than he would do if he went to court. However, there's no disaster, and these things are not entirely predictable. The solicitor may say you've got a watertight case, then you go on and lose, and you're very out of pocket. It makes things quicker, less hassle, less public, less embarrassing, because we have open justice. The courts are open to the public. People are allowed to report almost every case. There are very rare exceptions when they meet in camera, but there's national security implications. But if this is a sensitive issue, you can keep these delicate matters out of the press by having an out-of-court settlement. Legal costs are kept down by settling out of court. The whole issue is dealt with sooner. So people sue each other, but they could reach an out-of-court settlement. Sue comes from pursue, as you chase them through the courts. This applies to civil actions only, suing. People who start a civil action can withdraw it at any time. They will still have to pay their own solicitor's cost. And if you lose, you usually have to pay the other side's costs, well, if it goes to court. All right, judges. So judges are usually addressed as Mr. Justice name or Miss Justice name, all right? Depending on the level of the judge. They're red judges and purple judges in common parlance, depending on the colour of the robe. We shan't go into that. They don't wear full-bottom wigs all the time. There's one procession per annum when they do so, but the press gets a lot of mileage out of that. At a certain level, a judge is addressed as my lord, even if he doesn't have the title lord. Because remember, there's the Supreme Court. They used to be in the House of Lords, but they still do get the title my lord. Well, they still really are in the House of Lords, but they don't hear the case in the House of Lords. They hear it in the Supreme Court, just across Parliament Square. That's that. Only about 12 at a time are in the Supreme Court. The retired judges from the Supreme Court still have the title Lord for the rest of their lives. But there are other judges who be addressed as my lord, even though they don't actually have the title Lord. In ordinary life, they're Mr. whoever it is. So judges must be ultra respectable and neutral. They need to approach matters objectively. So judges strive to be unemotional and to avoid bias or any appearance thereof. They're there to uphold the law, to do justice. Occasionally these claims clash. Lord Hoffman said he felt very sorry for a party in a certain case, but he recognised that law and justice favoured the other party. He said he could see how much this issue meant to a certain person, but I'm afraid, on the law, that person was going to have to lose. Therefore, the Lord was duty-bound to rule for the other party, because the other party's case was founded on law and rooted more in justice. So judges have to recuse themselves when there could be a conflict of interests. Another famous example, 1998, that Bow Street Stipendiary Magistrate and Pinochet Ugarte, where Lord Hoffman, his wife, was a member of Amnesty International, an organisation which campaigned against Auguste Pinochet Ugarte for years, and therefore Lord Hoffmann recused himself, as in removed himself of the case, because there was a potential conflict of interests, just like Jeff Sessions recusing himself in the United States these days. There's no law against being politically active as a judge, but these days none are. If a judge brings the judiciary into disrepute, he or she will be required to retire, even if it's not actually criminal, just bring them into disrepute. They should refrain from making comments on political matters. And the appointments panel will look into that see someone's not too highly partisan, not high profile for the wrong reasons. We don't want infamy in the judiciary. Politicians should not publicly criticise judges, and they very rarely do so. Judges do not feel they can speak up in their own defence. They get other people to do so because they don't want to stray into the forum of public life themselves. Other people will speak up in the public sphere on behalf of the judiciary. Judges are said to sit on the bench. So if you said, I've been on the bench for 10 years, it means I've been a judge for 10 years. A recorder is a lower-ranking civil judge. For instance, Miss Cherie Booth, as in Tony Blair's wife, often called Mrs. Blair, but when court was always Miss Booth. They tend to use their maiden name. Female barristers who get married, even if they change their name in their personal life, their professional life, they usually remain known as Miss and then the maiden name. So when she was a recorder, Miss Booth, she practiced as a barrister, finding cases some days, acted as a recorder on other days. Now, she was a bit political, had been a Labour candidate years before. Her husband was a Labour Prime Minister, but that was still regarded as acceptable. So, above average barristers are the ones who tend to be appointed to the bench, i.e. they're made judges. Those who are below average are not regarded as being good enough, and the real high flyers would make less money if they became judges, so they don't want to take such a salary cut. So judges are paid a high salary to reflect their erudition and their status. It also makes them very difficult to bribe. Only one judge in the past 12 years that I've heard of was ever convicted of a bribe or even accused of taking a bribe. So judges are guaranteed good income, holidays, reasonable hours, they've got a secure job, handsome pension. These are the attractions of judges. They usually retire at 70, but that's probably going to age as we're a greying society. So judges can't be removed unless they do something disgraceful, nor can they have their salaries docked. The whole idea is to ensure their neutrality. The purpose is they can't be removed because they made a decision that was inconvenient for some vested interests. If they were penalised for making judgments that are uncongenial to the powers that be, that would very gravely impugn the independence of the judiciary. Let's look now at the Supreme Court. Panels of judges in the Supreme Court hear cases. This panel is called a constitution, as in a constitution of judges, usually made up of 5. It must be an odd number, so they can't have even 3 against 3 or something. If they disagree, there will be a majority. If an even number heard it, there could be a deadlock. Majority ruling is presented. One judge will give his opinion. He or she will express the view of the others. Once this judgment is delivered, the other members might add something else. Sometimes they say, I have nothing further to add. If there's a minority, then the minority will then state their opinion. That's the dissenting judgment. So in court cases, well, barristers, they normally wear a black gown, a white starched shirt with starched collar, a white wig, horsehair or synthetic, a black waistcoat, black grey trousers. Women can wear a skirt instead of trousers if they wish, so long as the garment is of the right material and colour. Barristers are wearing this anachronistic garb, they're said to be robed. Judges wear their robe and their wig. The barristers and judges are famous for the wigs. Judges seldom sport that full-bottomed wig. There's only use for that one procession a year, where the media garners so much footage, as I said. Now, solicitors sometimes speak in court, but they're not robed. They never wear those robes or those wigs. Child witnesses, if there's a case involving them, their special allowances may be made, and it's daunting enough to appear in the courtroom as an adult, but for a child it may be terrifying. So the judge may ask the barristers to appear unrobed, which doesn't mean in their birthday suit. It just means wearing ordinary suits, no wigs or gowns. It's intended to make the whole experience less bizarre and frightening for children. Okay, so barristers are a type of lawyer. There are 2 legal professions in England and Wales, remember, solicitor and barrister. After a law degree, someone can do the bar professional training course. If someone does not have a law degree, you can do the common professional exam. It's often known as the graduate diploma in law, which is a 1-year course in either case. And having passed the bar professional training course, they're awarded grades, either outstanding, highly competent, or else competent, or indeed fail. Well, it means you don't pass. So it's a demanding course, and after passing it, the person is called to the bar. That means like a graduate, that's their ceremony, the call. And he or she becomes a barrister, and they're called callees that day, those being called to the bar. So they wear their robes and wigs for the first time. The barrister will list their year of call, as in 1992, for example. And they might say, this is a job for only those who have at least 12 years call, as in were called 12 years ago or more. So it's like that. On a barrister's CV, you might say call, and they'll say 2004, so the year they actually became a barrister. Then they go on to be pupils. That's difficult, being an assistant to an established barrister. Do 2 6s, 6 months, and another 6 months for 2 different barristers, their pupil master. And if they successfully complete that, they're trying to get a tenancy, a permanent place in chambers. Chambers is an office for barristers. It could be just one barrister, that's very unusual. 20 or 30 would be more typical. And so they share the costs in the chambers. The tenancy is a permanent place. So long as you keep your nose clean, you're there till you retire. There are Inns of Courts for barristers, 4 of them: Gray's Inn, Lincoln's Inn, Middle Temple, and Inner Temple. They're all in London. A barrister must belong to one of these inns, even if he practices somewhere else in the country. They're all the same standard. It's not one's better than the other. They all do all types of law. They all do criminal, they all do family, they all do admiralty. It's not that they specialise. The chambers sometimes specialise. Remember, 4 inns, hundreds of chambers. So a chambers would be in Lincoln's Inn, or a chambers would be in Inner Temple. Chambers don't straddle the different inns. And we might say chambers collectively called a set. So we're a chancery set. They do that type of law mainly, or a criminal set, because they mainly do criminal, things like that. So the Middle Ages, there were sergeants at law, barristers, we now call them, who set up these inns, and they really were inns, as in the students lived there and dined there. They arranged accommodation for barristers and judges travelling around the realm. The word Templar came from the Knights Templar, who stayed in these inns on the way to the Crusades. There was an outer temple centuries ago, no longer exists. You should watch the Da Vinci Code if you want to know more about these Knights Templar, visit some of these very historic places. So each inn still has its own dining room, bar, library, chapel, even sports ground. So the inn is divided into dozens of chambers. Right. So a chambers could be in Newcastle or Cardiff or something, but it still belongs to one of the inns in London. So the barristers share the services of clerks, as in secretaries, who are mostly male, and they deal with the money and the solicitors. Barristers don't set their own rates, the clerks set that. The clerks want barristers to make as much money as possible, because the clerks get a share of that. There's a head clerk in every chambers and several clerks below him or her. So the head clerk is well paid, better than the junior barristers. The other clerks usually start on the minimum wage.